Thank you, Mr. Chairman. In his testimony during last month's hearing, Dr. Alan LaFawn presented modeling results that indicated that if emissions were reduced across the U.S. to achieve alternative lower ozone standards, that there would be a tendency for the fourth highest 8-hour concentration to occur not just during the summer, but also in some locations during the spring when the main contributors to ozone are background or natural occurring sources. The locations affected by the springtime shift can appear anywhere across the U.S. He also noted that with more stringent proposed standards, background would become an even more important contributor to exceedances of the standard. We all know that models have limitations, but we also know that some models are better than others. The modeling results that Dr. LaFawn described appear to be supported by EPA's own recent analysis. I would like to enter into the record a memo dated November 19, 2014 from Ms. Joanne Rice of the EPA. In her memo, Ms. Rice indicates that EPA is proposing that the ozone season be extended from its current period to longer periods of time. The result of EPA's analysis was that a total of 39 states across the U.S. experienced exceedances of the 60 parts per billion level during the spring. Background ozone is highest during the spring. As indicated earlier, ozone formation during the spring from man-made sources is much less than during the summer. It appears that naturally occurring ozone is a national issue, not just limited to Yellowstone and to the Intermountain West. The difficulties dealing with background ozone as experienced in these states is only a precursor for the entire nation. As a forester and an engineer, and after hearing much testimony in this and other committees, it appears to me that we have become so regulatory aggressive that we not only are regulating humans, but we're now attempting to regulate nature itself. Mr. Abernathy, Ms. Kessler, and Mr. Reese, my question for you is it time that Congress should revisit and modernize the Clean Air Act?
I will say yes. We talk about, at least my perception is their secretary is the administrator is supposed to use criteria requisite to protect public health. And so what does that mean? You have public health issues on all sides of the issue, the red cedar issue versus asthma versus other lung disease. And so I think that, and food, and the need to eat nutritious, economically produced food. So I think there are a number of factors that need to be considered in addition to define public health.
Mr. Westerman, the resounding answer is absolutely. When you come from a state like, especially in California, the Central Valley, where we've implemented virtually as many rules as we possibly can, even though we still have a no stone left unturned mentality. When you're approaching those background levels, the ability to get significant reductions through a rule process becomes extraordinarily difficult, if not impossible. And I think the best way to answer your question, and this has actually been proposed in California, that we have no farm days.
I would also agree with the other two members of the panel that it's absolutely time to revisit the Clean Air Act. From my perspective and the implementation perspective is that the Clean Air Act is very vague, and it's left to EPA to interpret the Clean Air Act, and then states are left to deal with the consequences of EPA interpretations of the Clean Air Act. So, especially with respect to background, international transport, rural transport areas, and the exceptional event rule, very vague in the Clean Air Act, and there's not a good precedent for implementing those with the current EPA rules.
And if you will hold those thoughts, I'll yield back to the chairman because I believe we need to go vote.
We have a vote on the floor that we've got to get to, but what we'll do is we'll just recess, and immediately following, we've got one vote. Immediately following the vote, we'll come back here and convene, and if you'd like to have 2.5 minutes of the rest of your time, we'll do that. Is that all right? Okay. Well, we are now in recess until after the vote. All right, we are back from recess, and we will reconvene. We were in the middle of my good friend from Arkansas, Mr. Westerman, asking 5 minutes of questions, and on the clock we had 2.5 minutes when we departed, so we will resume with Mr. Westerman for 2.5 minutes.
Thank you, Mr. Chairman. I believe Mr. Abernathy was in the middle of a thought when we recessed, so if you would like to pick up with that answer.
Thank you, sir. It would be remiss for me not to include that in my written testimony there was a series of potential modifications to the implementation of the Clean Air Act that I think would be a wonderful starting point for the committee to discuss moving forward. And also on your question of how it affects agriculture, Rule 4570 that I referenced in my oral and my written testimony has had an economic burden to individual producers in California to the tune of about $50,000 in cost just to implement and on an annual basis for Rule 4570. So that certainly takes away from spending money on potentially more important things from a dairyman's perspective when you're looking at those kind of costs ongoing on an annual basis, especially for small farmers.
All right. So, are there ambiguities and issues with the Ozone Acts that the judicial executive branch cannot properly deal with because the Clean Air Act hasn't been modernized? So, are there any ambiguities or issues that with Ozone Acts that the judicial executive branch can't properly deal with because the Clean Air Act hasn't been modernized?
I'll take a stab at it. I think this really lends to a unique opportunity for Congress to dive into this from the standpoint that in California, as I've mentioned, with a mature regulatory program, way all too often we're having our futures decided in a courtroom with a judge. And I'll let you think about that for a little bit, because that has nothing to do to benefit public health or air quality when you're in a courtroom and a judge is making those decisions based on a very stringent look at simply the law.
And Mr. Chairman, with that, I'll yield back.